The said letter only refers to the election held and the results thereof and nothing more. Further, no closer on closer examination of the special leave petition filed by Mr. Uddhav Thackeray before the Honorable Supreme Court challenging the ECI decision SLP number 3997 of 2022, I find that exactly same claim has been made about the letter dated 27/2/2018, and there is no mention about the new letter of 4th April 2018. Accordingly, said letter of 2/7/2018 is on the website of the Election Commission of India. However, there is no document relating to the constitution annexed to it. Hence, on this ground also, petitioner's submission that the constitution of the year 2018 has to be taken into account cannot be accepted. Petitioner's submission that submitted before the speaker, petitioner's submission that into inverted submitted before the speaker would mean into inverted annexed by the petitioner and the respondents in their respective petitions and replies thereto cannot be accepted, as there is a clear provision under the 1986 rule where the leader has to submit the party constitution. Rule 3 subclause 1 subclause B of 1986 rule mandates that the leader into inverted shall furnish into inverted a copy of the rules and regulations, whether known as such or as constitution or any other name, of the political party concerned. Further, Rule 3 subclause 4 contemplates that whenever any change takes place in the information furnished by the leader of the legislature party under Rule 3 subclause 1, he shall as soon as may be thereafter, and in any case within 30 days from the date on which such change has taken place, or within such further period as the speaker may for sufficient cause allow, furnish in writing information to the speaker with respect to such change. Thus, the submission of constitution before the speaker has to mean submission under Rule 3 of 1986 rules. However, till date, Shiv Sena has not submitted any constitution on the record of the speaker under the said Rule 3. In view of the above observations and finding, I need not further analyze any other submission in this regard made by the parties, and I hold that the Constitution of Shiv Sena provided by Election Commission of India, VDA, letter dated 22nd June 2023, is the relevant Constitution of Shiv Sena for determination of the preliminary issue as to which faction is the real political party. Constitution of Shiv Sena held to be the relevant constitution is hereinafter referred to as the SS Constitution. The leadership structure relevant for the determination. Learned Senior Advocate Mr. Kamath's submission that the leadership structure which is relevant for the purpose of deciding the preliminary issue is the leadership structure which is reflected in the communication dated 27 February 2018 and 4th April 2018 made to the Election Commission of India pursuant to the elections held on 23rd January 2018 is based on the petitioner's submission recorded in paragraph 89A to G herein above. Initially, the petitioner relied on the affidavit submitted to the ECI of the then office bearers of Shiv Sena, produced along with the affidavit in lieu of examination of chief to show that Shri Uddhav Thackeray had support of the majority in the organization. Respondents objected to such production on the ground that it is not permissible to produce affidavits of others along with petitioner's own affidavit in lieu of chief examination without the author of the said affidavits subjecting themselves to cross-examination. In any event, during the arguments, Mr. Kamath did not rely on these affidavits and limited his submissions to the 2018 leadership structure as available on the ECI website. Mr. Jethmalani, in turn, focused his submission to buttress the ground that the said leadership structure